all. Thank you for getting that recording started. And I was just explaining that this webinar is brought by a partnership between the Santa Cruz Superior Court and Senior Citizens Legal Services. So we will be recording this today, and this will be posted on our website for future reviewing. Because of the recording, we're going to save all our questions for the very end. So please do write your questions down, hold them tight. If I don't explain them sometime in the webinar, then we can try to address it at the end. And if it's something that I can't answer or otherwise will take more time, then please do know that, like I was saying, we do have staff at the law library to help answer information, help you fill out forms, give you your pros and cons for choices going forward in the housing situation that you may find yourself. So we have done several of these webinars in the past several months. We've done a few from landlord perspective, and this recording today is going to be on the tenant's perspective. So I'll be focusing on what an eviction looks like when you are in the shoes of a tenant, potentially not wanting to leave or perhaps ready to move on. Whatever the situation may be, I will be giving you the lowdown of how that works. So again, Buffy, thank you for helping me out, and Renee at the courthouse, thank you for helping get the logistics going. And let's go ahead and get started. The first slide, I believe, is just a timeline. Well, that's important also. That was just the address and phone number for where you can get services. We'll jump back to that. So once again, currently Buffy Almendarez is in the courthouse on Tuesdays and Thursdays all day. And even when she's not there, the law library has long been very well versed in housing law and does provide lots of information. So if you have any questions, you can also address them by phone and by email. The Self-Help Center the law library phone number is 831-420-2205, and Santa Cruz Law Library at gmail.com. Those are both really powerful ways to get answers asked. Not every county has such services. So we're lucky to have those available in person, via email, or via phone. So hopefully you get all your needs met in those ways. And now we'll get started with the presentation itself. We're going to start by going over a timeline. Super important because, as you can imagine, often the most important thing for a tenant to know is how much time do they have to find a new home and to get themselves settled in a good way. We always try to help people have what we call soft landings. You don't want to be at a place where you are not ready to go elsewhere. So good to know that that first notice that is required to be given to you, the paper notice that a landlord has to provide to you, is not the first step in the eviction process. So if you get a 3-day notice or a 15-day notice or a 30-day notice or whatever the notice is, that's still other things that have to take place after that notice period, as shown here in the timeline. So again, the first step is that you'll get a notice. Again, one of the time frames that I mentioned previously. We'll go over that in another slide, what the different notices might look like. But after that notice period runs, hopefully you have already found a place and you don't have to deal with the rest of the hassle. But if you have not found a place yet and you're not able to leave by that notice period, then you get into the unlawful detainer world, the court process to actually evict a tenant. So step 2, after the notice period has ended and the tenant has not left, is that the landlord then has to file all the paperwork, pretty complicated paperwork they have to all fill out and file at the courthouse, and then personally serve the tenant with those court papers. So step 3 is what we would consider the service period. After you have been served, typically you have 5 days. It's a very, very, very important step in the process. After you have received the court unlawful detainer paperwork, you have 5 days to file your response. We'll go into a little more detail about that as well. There's some some situations where you'll have slightly more than 5 days, but make sure you know what your timeline looks like, because if you don't file within that 5 days, the landlord can get what's called a default judgment. So hopefully you have filed your response in that 5-day period, and we get into what is step 4 on this timeline. So after you have filed your response, the landlord then has to request a trial with the court. So they file another paperwork with the court to set the case for a hearing. And that hearing is typically going to be about, well, it says 20 days there, about 3 weeks or so from the date of requesting the trial and the trial date itself. Once you have your hearing, your day in court, your opportunity to provide all your defenses and state your story to the judge will make a ruling. This, I will just say right here at the front, is the day you don't really want to get to. You don't want to have a judgment against you. I guess if you win, then you would want that, I suppose, but it's still a hard process nonetheless. But the number one thing that I would like people to know is that you really, really, really don't want that unlawful detainer judgment. That's after the court hearing, when the court actually declares that the landlord has won the trial and there is a judgment against you. That is what's really relatively harmful in trying to find a new home. So important to know that date there. But after you have had your trial date is when you would be in what's called here step 5, where the landlord would be given a writ of possession. And again, that can either be by default if you never did file that response, or by order of the court after the court hearing. So the writ of possession paperwork is what is finally given to the sheriff. So now we're finally in step 6 or so. And the writ of possession is what the sheriff will then post on your door. And at that point, they generally say that they will be back in 5 days. So it's a notice that says we will be back in 5 days. And if you are not out within that 5-day period, then that is the very unhappy moment where the sheriff has to actually physically remove you from the home and re-lock the doors. So we don't want to get to that point. And there is a few steps that you can always try to file before the sheriff comes back in that 5-day period. You can try filing a set-aside motion, or a stay of execution, or an appeal. So we'll go into more detail about all these different steps, but it's really important to start at the outset just to see the timeline. And again, the most important part of this, the timeline, is so that you realize that when you first are given that notice, there are several other steps that have to take place before you'll actually physically be removed from your home. And it's important for the landlords to know as well that it's not, not as easy as the one notice up front, but there's lots of other paperwork that needs to be filed and lots of other processes. So we will talk a little more about each of those steps, and that is the overall eviction timeline. And go to the next slide, please. So when you are given the unlawful detainer notice from court, when you've actually been served with the unlawful detainer court process. So this is not yet talking about the actual notices that you may have been given before the court hearing. But after the notice period has run and the landlord files the unlawful detainer in court, and you have been served, your time period to file your response, I said previously when we were looking at the timeline that it was a 5-day period, but that is only if you've actually been personally served with the papers. This is the, well, I don't know if it's the most common, but probably the most common, or the preferred method of service is when a process server or anybody who's over the age 18 and not a party to the case, any such person serves the documents on the tenant. You have then been personally served, and then you have 5 court days to file your response. Again, if you fail to file your response within that 5 court days, the landlord can just turn around and request an immediate judgment, a default judgment against you, which you do not want that judgment against you. If you haven't been personally served, if it's either been substituted service or what's called post and mail, then there is some additional time granted. The substituted service would mean that the document was left with an adult at home or your work. I don't see that happen very often, but it can be the paper's adult who is in charge either at your place of home or your place of work. And then after those documents have been given to an adult in charge, another adult, then the documents have to also be mailed to your residence. So if those two things do occur, then you have been served via substitute service. And in that case, you have 10 calendar days and 5 court days from the date of mailing. So you will see, hopefully the proof of service document or the mail itself will say the date that the document was mailed, and you have 15 days, 10 calendar days and 5 court days to then file your response. So the third way that you might be served these unlawful detainer papers is called post and mail. These are somewhat hard to get, but definitely not impossible. But this would be after 3 unsuccessful attempts. So the landlord or a process server has driven by your home on 3 different occasions and have not been able to find you. Then they can apply to the court, fill out another form, and get court approval to post and mail. So the papers are simply posted on your front door. This is similar to how a 3-day or a 15-day notice can also just be posted to the door. But so this unlawful detainer paperwork can be posted on your door and then mailed to your residence. And again, if those 4 things have happened, then you have been considered served by post and mail. And once again, you have 10 calendar days and 5 court days from the date of mailing. So again, it's really important to know how you were served and then how much time you have to respond. If you have any questions at any time, please do seek attorney legal help or the law library or our offices to make sure that you understand when your response is due, because you want to make sure you have the opportunity to present your side and not get that default judgment against you. Okay, next slide. This is a somewhat interesting and somewhat complicated situation, but it's not uncommon that there will be people residing in the home that are not named in the unlawful detainer paperwork that was filed with the court, or not named on the notice documents themselves. So these are called unnamed occupants. They're also known by the term DOEs, D-O-E-S. And essentially a DOE in a lawsuit is a party who is unknown as of now, so unnamed. So most frequently landlords should click the DOEs box on their complaint paperwork and serve a prejudgment claim of right of possession on any individuals that they believe might be unauthorized residents or might be living in the home, even though they're not on the lease or otherwise. So the prejudgment claim of right of possession is an important form to understand. It's also called the CP 10.5. And essentially this has to be also personally served on the unnamed occupants. If with the summons and complaint with the unlawful detainer paperwork, if there is this prejudgment claim of right of possession and you have received it or see it, then you have 10 days as the unnamed occupant. You have 10 days from the date of receiving this prejudgment claim of right paperwork, 10 days to join the case. So there will be a landlord and a tenant named in the case already, and these unnamed occupants often have to figure out what to do. Sometimes it's best to not respond to the prejudgment claim of right of possession because sometimes you don't want to enter the case and then potentially have that judgment eventually against you on your record. So if possible, sometimes it's easier for the unnamed occupants to move out at this time. But if they do decide to enter the case and they want to present their information to the court, then they would do it now at this time. If they do not do it within their 10 days, then they have 10 days to to turn in that form, and then the court will determine whether or not this individual should submit an answer or have a stake in the case. And they then have 5 court days to file an answer. If the summons and complaint does not include this prejudgment claim of right of possession, if the unnamed occupants never had opportunity to enter the court case, later when the sheriff is showing up at the door and ready to lock the door or ready to enforce with the writ of possession, at that time the sheriff will actually give the unnamed occupant the same form, and they have days. They can go immediately to the courthouse with that form and actually prevent the execution of the writ. Only temporarily. They can prevent it just within days. The court will basically hold another hearing for this individual when they show up at that time with the form. You have to pay rent if you want 15 days before your hearing will be held, or if you don't pay rent at that moment, the court will hold the hearing, usually just within a few days, and decide if you have any opportunity to then present your case as a tenant. So that's what happens with unnamed occupants. Again, a little bit confusing with the prejudgment claim of right of possession, but you can always ask questions along the way at the law library or senior legal. When you are served with the unlawful detainer, you got to decide what to do with it. Sometimes, I will always say that negotiation is best. You really want to start at this point to try to negotiate with your landlord, try to see if they can agree to a stipulated move-out date, see if there's any way to make an agreement with them, without having the court case continue. But you probably want to file one of these 3 things in order to preserve your defense, your right in the case. Most commonly, you'll simply file an answer. An answer is where you have opportunity to include all your defenses. You can put any arguments about, well, we'll go into what some of the potential defenses are, but this is where you would write any defense you have. You can write a statement, you can write a declaration, you couldn't provide evidence if you want right then and there with the answer form. But in any event, you're going to file your answer. And after the answer is filed, that request for trial is then filed and trial date set within 20 days. This is a judicial counsel form, which means it's a form that, with check boxes, so it's relatively easy to fill out. I won't say easy. I shouldn't say easy, but it is a form, and there are boxes that you can check out. The other 2 documents that we'll talk about possible responses, both the motion to quash and a demur, there is no form for it. So it needs to be created as a motion on fancy paper called pleading paper. So you will need help most likely at a law library or Nolo Press or an attorney to help you with these sorts of documents. But a motion to quash essentially would be used if the service was not proper, or if they simply didn't state a cause of action. If something was so off that they shouldn't even have filed in the first place, essentially. So the motion to quash can be filed, and after a hearing, if you are correct and you were not served properly, the judge will grant your motion, and then the landlord will have to start over again with a service, with reattempting service. If you don't win, if you lose at that hearing, then you still have that 5 court days to file your answer, and it'll proceed as if you had filed the answer. Another type of response that you can file is a demur. A demur is when there is a defect in the notice or the complaint A little bit confusing sometimes about the differences between a motion to quash and a demur. So again, you can always ask for further assistance from an attorney or at the law library. But this is a demur. Again, if there's a defect in notice or the complaint is so great that they should not be able to even proceed with the case, and you shouldn't even have to have a trial essentially, then the court may grant your demur. If you win the hearing again on this demur, then the whole case is thrown out and the landlord has to serve a new notice. Once again, if you lose at this time, then you have the 5 court days to file an answer. So those are some possible responses to the unlawful detainer. If you are filing your answer, you're going to definitely want to know these common defenses, and you probably want to, in a best case scenario, talk to an attorney or somebody who can help you analyze the situation and analyze whether or not any of these defenses, are viable defenses, whether or not any of them apply to you. Most commonly is the defective notice defense. And you'll see that, sometimes people will use a defective notice and file a motion to quash or a demur, as I mentioned. But again, those are somewhat complicated forms, or not forms, they're somewhat complicated pleading documents to put together. So you can also simply, in your answer, name the notice as being defective. So there are really strict rules with how notices are served and how the unlawful detainer itself is served. But this is more in reference to the 3-day notice or the 15-day notice or the 30-day notice. So if those were not given to you exactly as it needed to be, then this is a really common defense. Importantly, we're going to talk a little bit about the Tenant Protection Act, that is the TPA, that is really governing all evictions at this point. And there really were a lot more strict rules given with respect to how notices are provided. So if the TPA was not followed properly, then this would be where you would note that in your answer. You can also plead what's called waiver. The landlord says that they want you out, but then they've waived that request if they've accepted rent after that notice period had expired. So if that's one really important notice, especially if the notice itself was first based on non-payment of rent, then the landlord accepting rent is certainly a waiver, and they should not be allowed to proceed in the unlawful detainer hearing. Another frustrating situation, often hard to prove, unfortunately, is retaliation. But definitely not impossible to prove, and particularly if the unlawful detainer is brought within 6 months after raising a habitability concern or exercising other legal rights, then you are well poised to show the court that they are merely evicting you for raising your legal rights. It need to be careful. Again, this can be somewhat hard to prove, and particularly with the habitability concerns. There are a lot of homes that are not mansions or not perfect, but it has to be a real serious concern. It has to be a concern that does lead to the level of habitability concerns, and you have to have given that notice in writing most commonly, or at least alerted your landlord that you believe this is a habitability issue. So merely having an unsafe home is not going to help you in the retaliation arena unless you have gone about raising the habitability concern in the right way. In any event, retaliation is a very common defense and an important one to understand. Also, discrimination can also be hard to prove sometimes, but it's very, very important. And especially in this day and age of all of us working so hard to be just and aware, we need to be very aware that there can be discrimination based on many things: race, sex, religion, marital status, sexual orientation. Number of children is an interesting one. There is definitely family discrimination that does occur and needs to be brought to attention. Of course, disability, those sorts of things, income discrimination. They're allowed to charge what they want to charge for their rent, but they can't discriminate against you for being on public assistance. This is a really big one in Santa Cruz County. You're not allowed to screen people for being on Section 8 or otherwise receiving public assistance. And finally, there is kind of a whole other world of potential defenses. So again, make sure you talk with somebody and see if any of these might apply to you. If your landlord refused to accept rent before a 3-day notice to pay or quit expired, that could be a defense. If the landlord gave you multiple notices, a 3-day and then a 50-day and then a 3-day and back and forth, you could argue that you were very confused about which defense or which notice was the one. And if your landlord agrees to other terms after giving you notice, or if they agree to let you stay after giving you notice, those are some other potential defenses that might be able to help you in court if you get to that point. But none of it's easy, so keep your notes, try to keep your documentation of what's occurred, and do your best to get some assistance before showing up in court if at all possible. So I mentioned the Tenant Protection Act. This was a relatively new 2020, started with some pretty big changes on notice requirements. But we will also get into, on the next slide, the exemptions. So there's also not every tenant is protected under the Tenant Protection Act. So you got to start by understanding whether or not your property, whether or not the residence where you live is covered by the TPA or not. If this is a TPA property, then these are some of the additional protections that are given, particularly with any 3-day notice. There is an additional, basically an additional 3-day notice that is now required to be given. So you have to be given the notice with opportunity to cure. So you have your 3-day with opportunity to cure or opportunity to pay, and then given your 3-day notice to quit. So previously it was just a 3-day notice to pay or quit, and now there has to be the 3-day notice to pay or quit, and then a 3-day notice to quit if they do not cure within that 3-day period. So that's an important new protection that is super critical in a lot of these situations. Also, we now have a new 60-day notice requirement. Previously, almost all notices were just 30 days, but if you have lived in a TPA covered property for more than 1 year, you are now entitled to a 60-day notice. So that was a big change and an important change. And when you're given this 60-day notice or the 90-day notice, we'll discuss next, that notice will either be at fault or a no fault defense, or sorry, notice, not a defense. It'll either be an at fault notice or a no fault notice. The at fault notices, we'll go over what those are. A no fault notice there's only about 4 reasons that count as no fault. So that doesn't mean that you don't need to have just cause. You do need to have just cause, but it's either going to be at fault or no fault cause. If it is a no fault reason, which we'll discuss, then the tenant is entitled to 1 month of relocation assistance. So 1 month's rent is typically waived. Their last month's often waived, or otherwise they have to be given 1 month of relocation assistance. So that's the 60-day notice requirements. And the 90-day notice requirements is if you are a Section 8 housing voucher or otherwise are receiving public benefits for housing. There was a lot of controversy initially as to whether or not these Section 8 tenants were covered by the TPA or not, but most recently the Attorney General and most organizations are certainly arguing that Section 8 tenants are protected by the TPA, and thus they also have to have either at fault or no fault cause stated in their notices, and their notices are required to be 90 days. That has always been a 90-day notice requirement for Section 8 housing voucher holders. But again, now adds the cause requirement of either at fault or no fault cause. And let's go to the next slide. We'll dig into that a little bit deeper. So like I said, there's really only 4 no fault causes that are required. So it's not just, you can't just do it for no, you can't evict just for any reason if the individual has been there for more than a year, but you can do this no fault cause if the owner of the property or immediate family, doesn't mean the long lost cousin in Iowa, but the owner or immediate family moving into the home would be a no fault just cause allowed reason. Also, if you are withdrawing the property from the rental market, so you are no longer choosing to rent the property at all, that would be a no fault just cause reason. Owner complying with a local ordinance or government agency or court order if they were somehow required to demolish the property, or if it was red tagged, for example. A red tag does lead to a no fault, although there are other compensation allowed in such situations, in addition to the 1-month relocation assistance provided for here. And the 4th reason is intent to substantially remodel the property or demolish the property. I think it's important that those 2 things go side by side, because a lot of people think that just any remodel might suffice, but it's really not just any remodel. It's a substantial remodel, potentially similar to a demolition. I don't know about. So those are important to know. And again, if any of those 4 reasons are named in the notice and in the unlawful detainer paperwork, then the landlord is required to pay the tenant 1 month's rent as a relocation assistance. Going on to at fault, there are quite a few reasons where the landlord would be allowed to evict a Tenant Protection Act property without paying any relocation assistance, and some reasons also would lead to a 3-day notice, to cure potentially, and if it's severe enough, not even with a cure provision. Although I guess with the TPA, you have to have the notice to cure now also. In any event, these are the at-fault reasons: non-payment of rent, material breach of lease, not just any breach of lease, but a material breach of lease, nuisance on the property, destruction or waste of the property, a tenant refusing to execute a written lease renewal or extension can be considered fault, but you have to be careful. It has to be a similar lease. It has to be nearly identical. They can't change it all and then force you or evict you for not signing a changed lease. But refusal to execute a written, substantially similar lease can be at fault. Criminal activity on the property, unlawful subletting is a really common and problematic one that we see given how the housing shortage is affecting everybody. Certain refusals to allow the landlord entry if they have given proper notice. The landlord does have right to inspect the property if they've given proper notice, usually just a 24-hour notice. So if you are refusing to allow entry, that can be considered a reason for just cause eviction. And other use of the property for animal fights, weapons, drug manufacture, trade. Refusals to vacate by a terminated employee is an interesting reason. Sometimes if there's a work relationship, like a property manager at the home, there's no longer have that work relationship, but they are not refusing. If they're refusing to leave, that could be a fault. Or a tenant failing to vacate after giving landlord their written notice of intent to vacate, that would be considered an at fault just cause reason. And again, if the just cause is curable, if any of these things is curable, then they would have to be given the 3-day notice to cure this fault. And if they don't cure, then the 3-day notice to quit. So that was a mouthful of just cause reasons. But once again, you're gonna, if you are covered by the TPA, you'll figure out if they are naming this as a fault or a no fault eviction, and figure out if that is accurate or not. Okay. Like I mentioned, not every home is protected by the TPA. Some people have said that this long list of exemptions somewhat swallows the protections in the act themselves, but it is still an important act. And again, anyone that has resided for more than a month or more than a year is generally protected. But if all the tenants have lived in the property for less than 12 months, or if there's more than one tenant and no one has been over 2 years and less than 12 months, depending if there's the people in the home. So it gets a little bit confusing if there's more than one tenant. But again, if there's only one tenant, if they've lived there for less than 12 months, if there's multiple tenants and no one has lived over 24 months and any tenant has been on the property for less than 12 months. Hope I'm reading that correctly. That would be exempt and no longer protected by the act. Tourist hotels are exempt. Nonprofit hospitals are exempt. Residential care facilities, licensed care facilities are exempt. Student dormitories are exempt. Owners' principal residence, where they share a bathroom and a kitchen. This is, again, relatively common in our high cost of living here in Santa Cruz. So if an owner is residing in the home and renting out other rooms and sharing the bathroom or the kitchen facilities, then that is not a protected property. Also, a single family owner occupied residence is not a protected property where the owner rents or leases no more than 2 units or bedrooms, including accessory dwelling units on the property. So if it's a single family owner occupied residence and they are not renting more than 2 rooms or 2 accessory dwelling units, then that is not a protected property. 2 units in a single structure in which the owner has occupied one of the units as a principal place of residency since the beginning of the tenancy, that is not protected. That is common in a duplex situation, so where there's 2 duplexes and the owner lives in one and has lived in one since before he began renting the other one to the other tenant. In that situation, that tenant would not be protected by the TPA. Also, a big exemption is all housing built within the last 15 years. Essentially, the state did not want to prevent new development from going up, not wanting to prevent new housing, for example, from being built. So any home that was built in the last 15 years is exempt from the TPA. I think we're getting through this. This is a big slide. A couple more here. Property alienable separate from the title to any other dwelling unit. And if it's not owned by a LLC or a real estate corporation, and they've given notice to the tenant of this sort of situation. So that's a complicated one. Feel free to reach out and ask further questions if you think that you might fall in that world. Affordable housing properties are often not provided at TPA exemptions, housing that's been restricted to provide affordable housing only. And then if there is other local rent control or just cause ordinances that are greater than the TPA, then the TPA would also be exempt. It wouldn't apply. Obviously, you'd have the local rent control and other ordinances that are more protective. So those are a lot of exemptions. Again, you always want to check and first thing first, am I protected under the TPA or not? Thank you. But to the next slide. We did already talk a little bit about default, but I want to mention it again because it is really important. Again, you know, either a default judgment or order after hearing signed by the judge. Either way, the default judgment or the order after hearing signed by the judge is going to get you a writ of possession and is going to go on your record. And in this, again, with the housing market being the way it is, it's kind of the worst case scenario is having a UD judgment on your record, because other landlords are able to see that when they file their when they're considering whether or not to rent to you. We all know how hard it is to find housing. So we do not want to get a default judgment. Make sure you know your response time once you've been given the unlawful detainer paperwork. Is it a 5-day or is it a 15-day? You don't want to get the default judgment paperwork. Default just given to the court. The court gives the writ of possession to the landlord, and the landlord takes it directly to the sheriff. Sheriff posts a notice at your house and tells you they'll be there within 5 days. So avoid the default at all costs. Make sure you know your response times on filing your answers. Next slide. These are some possible trial outcomes. Again, if we talked about this a little bit when we went over the timeline, but if you have filed your answer and the landlord has filed their request for hearing and you are therefore at court, obviously either the landlord's going to win or the tenant's going to win. You also do have mediation option. I should mention that now, and I probably should have mentioned it earlier, but there's always opportunity to mediate at any time in this process. Conflict Resolution Center is part of this important collaboration with Senior Legal Services and the courthouse. And they are providing free mediation services to landlords and tenants to try to work out all these details of when will they leave and how much money is owed, et cetera, et cetera. We don't, unfortunately, have a day of court mediation. So if you are in court, you unfortunately don't have opportunity to mediate right then and there with a professional, but you can always make agreements in the courtroom. You can always, try to make an agreement, negotiate, at the side of the door before you go talk to the judge. So you keep that in mind. But otherwise, the trial outcome is either going to be a landlord winning or a tenant winning. If the landlord wins, like I mentioned, they're going to get that writ of possession paperwork, which they will take to the sheriff's office. The sheriff will then post a notice on your door, that icky piece of paper, which says we're coming back in 5 days to remove you. I have been told, I don't know if it's recent or not now, but there was about a 2-week delay. The landlords had so many writs of, the sheriff had so many writs of execution to try to execute on. So it might be slightly more than 5 days, but generally it is 5 days of removal once that notice is on your door. At the trial, the landlord can also get a money judgment against you, and that can include attorney's fees and costs. So yet another reason to try to negotiate or mediate before having a court trial. Attorney's fees can get very high very quickly. If you do win at the trial, if the tenant is successful, then the landlord cannot proceed with the eviction, and they have to start the process all over again by giving a new notice. So they could start again by giving a 3-day, a 15-day, a 30, or a 60, whatever is required. But it is possible for them to start again, and the timeline just starts clicking all over again. There are a few other post-judgment actions that are possible. They're not easy and they shouldn't really be relied on, but it is possible. Most importantly, you can file a motion to set aside a default judgment. So if you failed to file your response within that appropriate time, either the 5 or the 15 days, you can quickly file a motion to set aside your default with the court. When you file your motion to set aside the judgment, You will also file your answer that you failed to file previously. So you will file them together, and the judge will determine whether or not he's willing to accept your motion and then go on to review the answer that you filed. And then the trial will be set after you've had that answer reviewed, and you'll have another opportunity, or you'll finally have your opportunity to have your day of court. But that is a motion to set aside a default judgment. If you have already had your day of court and have failed, if you did not prevail at trial, there are some appeals that are possible. Not easy to prove to another judge that the current judge made an error, but you certainly can try to file an appeal of the judicial process. That is another paper that has to be filed, and then it goes up to a different judge, a court of appeals. And appeal paperwork needs to be filed within 30 days after you've received your notice of the entry of the judgment. Very strict timeline on that 30 days. And there's also an ex parte application for stay of execution. It's a complicated term for begging the court for more time, essentially. So after the judgment, perhaps begging is a bit strong of a word, but that's more or less what it means. After the judgment has been granted, you are allowed to explain to the judge the extreme hardship in moving out immediately, and you can be given up to 40 days additional to move out. You do have to pay the daily rental value for the days that you are staying, and you actually have to pay the day of your hearing. So you have to get your paperwork done correctly. You got to get that filed correctly, and then be prepared to pay for the time that you will be staying longer in the home. So that again is an ex parte application for stay of execution. Can be done before you are officially kicked out. Abandoned property is important to know. Lots of people have a hard time moving all of their belongings in the time that is granted. And often, unfortunately, there is stuff left behind. You do still have a right to collect your property if you were unable to take it with you immediately, but the landlord basically has to provide you a written notice that you have property remaining. And after giving you notice, they have to store the property for 15 days and allow you that time to go back and get the property. If that's not done correctly, a tenant could potentially bring a landlord to small claims court or otherwise assert that they have been, their property was not handled appropriately. So this is called the abandoned property provision. And again, the landlord has to give notice to the tenant. Thank you, Buffy, for helping with the questions. I see them coming in and we will get to them. But again, because of the recording of the webinar, I wanted to make sure to get through the whole thing in the time permitted. So almost done, and then we'll try to answer some questions. Is there another slide? Oh, the security deposit. Everybody wants to know about their security deposit. Very, very important when you are trying to move that you do get your security deposit back so that you can afford the new home that you're moving into. Sometimes this is more critical to some than others, but everybody does deserve to have their security deposit returned if the home is given back to the landlord in good condition, other than normal wear and tear. So it really, really comes down to what is normal wear and tear, a very frequent concern, and there's lots of information out there about what normal wear and tear is. Primarily carpets and walls, those do get dirty after you've been living for a certain period of time, and a landlord can't charge you for those things, but they can charge you for any other damages done to the home. They can also include unpaid rent, or again, any other repairs that they had to make by damages caused by the tenant that can be deducted from the security deposit and not returned. But any deduction that's going to be made needs to be itemized in a written list and given to the tenant within 21 days. So it's very, very important that within this 21-day period, 3 weeks after the tenant has given up possession of the property, the landlord has to provide an itemized list of what security deposit amount they are going to return and what they are proposing to keep. If they haven't got all the work done and know the exact costs by that 21-day period, that's fine. They can just lay out what they expect the work will cost and then follow up with receipts shortly thereafter, after the work's actually complete. But if you as a tenant do not get your full deposit back and this itemization within 21 days, you actually can get your full security deposit back and double the damage if you are able to show that the landlord retained the deposit in bad faith. This is typically done in small claims court. A tenant would need to write a letter first to the landlord explaining your concerns, your opinion about the money that should have been provided to you. If the landlord does not respond to your letter or are not willing to hear your concerns, then it would be a relatively simple filing in small claims court to allow a judge in small claims court to decide whether or not the security deposit was rightfully withheld. So that's how security deposits work. And again, make sure you can always ask questions of anybody at Senior Citizens Legal Services or at the Law Library for assistance. Again, there is the phone number you can call at the Law Library and the email. Buffy is available all day Tuesday and Thursday for now to answer questions at the Law Library. Buffy, do you want to read some of the questions that we have gotten so far?
Yeah. Our first question is, can you please clarify the difference between 10 days and 5 court days?
Yeah, it's a little bit, well, it's basically just what it says. Court days would include holidays. So it's basically a calendar day. It's just, if you're looking at the calendar, it's every single day of the week. A court day doesn't include weekends or holidays.
Our next question is, does a waiver defense require to withdraw the case?
Well, nothing requires the withdrawal of a case. It just would hopefully have a court agree with you, and the case could be won by you in court. So I don't think anything requires the withdrawal of a case in that sense. But hopefully, if your landlord is negotiating with you and hearing you explain the waiver defense, then they would voluntarily choose to close the case because they might agree that you are correct. Doesn't always go that way. Typically, they want their day in court and they don't agree with what you are saying the defense is. But that does lead to negotiation and opportunity to mediate, etc.
Next question is, which are the most common reasons to file a motion to set aside default? Can it be in a hospital? Being in a hospital, could that be a good reason?
Yes, absolutely. And I would think that's probably one of the best reasons. You know, anything that's documented, such as being in the hospital, is probably going to be a really solid motion to set aside. You know, sadly, basically anything that's not the tenant's neglect is a viable reason to file a motion to set aside the default judgment. But certainly illness, being in the hospital, you know, it becomes questionable when, when mental illness or mental reasons are the reason that the tenant failed to accomplish their answer on time. But even in that situation, I mean, you can always file your motion and you'll have the opportunity to present to the judge your reasons. I think that the courts generally want to allow individuals their time in court. I think that they probably weigh on the side of granting motion to set asides. Perhaps that's a bit bit too big of a statement to make, but in general, they don't like to shut people down and not allow them their day in court. So those are all some reasons to file that motion to set aside.
We have one more question here. It says, how do I get my landlord to clean up a mess he made in the yard if it's hazardous, for example?
Well, yeah, you do have the right to quiet enjoyment of your home. And if there's something like that, then he is responsible for it. I certainly think that everything in writing and hopefully as calmly as possible is always the best way to start. I really like text messages or emails because it's just kind of a friendly communication. It doesn't have to seem too intense or nasty, but you also have documentation that you made these requests. If it is actually hazardous, and you'd have to get some kind of proof of that, I suppose. I'm not quite sure what kind of mess it is or what kind of hazard it is, but if it is toxic waste, for example, that is therefore affecting the habitability of the home. After you put your request in writing and he has failed in some reasonable time frame to clean up the mess, then you are allowed to do your rent reduction. But again, you have to be really careful with these because you don't want to get into all of a sudden you're evicted for not paying your rent and you're trying to prove that you did this properly. But if you have it in writing, you made the request, he hasn't cleaned it up, and then you put in writing, I am going to pay so and so X amount of dollars in order to take care of this mess that you are not properly taking care of. I am going to deduct that amount from my rent. If you do all that properly, then that is the way to handle a habitability concern, such as a mess in a yard. Again, if it's not toxic or hazardous, otherwise the mess in the yard is probably not going to be a habitability issue that would allow you to do a rent reduction, but it just depends on how extreme the mess is. And if it's diminished the value of your property, then yes, you wouldn't have to pay the full rent during that time, so long as you've made all the right documentation that that's what's going on. I hope that helps.
It looks like that is all the questions.
Okay, I do see one thing in the chat. Is that something different? Oh, that was you. Okay. Well, if there's any other questions, feel free to bring them on and see if we can help. Otherwise, I really appreciate your all attending, and we hope that everyone stays safely housed and that landlords are also given their due right to maintain their homes. And I really want to say again that the Conflict Resolution Center is also a really great partner of ours. And, we also, any person that comes to us at Senior Citizens Legal Services, we will consider if mediation is a possibility and try to get them to Conflict Resolution Center if at all possible. We really want to see people doing all they can to resolve these disputes before it gets to the courthouse, because believe me, it's not fun for anybody. And Linda, I see that, thanks Buffy, sorry, I was staring at it. If you would like to be emailed the PowerPoint, we can definitely do that. If you want to put your email in the chat, would be most probably best to put it right in the chat right now. We can get that down and we can get that over to you. Okay, thank you very much as well. You guys have a great day. Go eat all your leftovers if you have any. And thanks again for all your help, Buffy and Renee.
Thank you. I'm going to stop recording.